Hi, I'm John Cam with Canada Associates, your fierce advocates, and today I'm going to be talking to you about how to successfully navigate your divorce. I'm going to give you three of the do's and three of the don'ts. Do protect yourself. If there are safety concerns or significant financial disparity, you should consult an attorney to discuss legal representation. An attorney can advise you on your rights and ensure your interests are protected throughout the process. Do consider mediation. Exploring mediation is a potentially less adverse and less expensive way to reach an agreement on division of assets, child custody, which allows a neutral third party to evaluate both sides of the case to help you reach resolution. Third, do place the interests of your children first. If there are children involved, it's important to prioritize their well-beings. You should create a parenting plan. Also, communicate the financial responsibilities for their needs with your spouse and with your attorney. Here are three of the don'ts. Don't rush the process. Take time to understand your options and make informed decisions. Rushing can lead to costly mistakes and allowing emotions to cloud your judgment. Second, don't hide assets. Full financial disclosure is crucial. Hiding assets will only complicate the process and damage trust between you, your attorney, and potentially the court. Three, don't discuss the divorce on social media. Social media posts can be used as evidence in court. I've seen many times where copies of these documents are printed off and simply put into the record of the court. These are some of the important do's and don'ts in the divorce process if you're facing this issue in Oklahoma. I'd like to address some of the most common questions that we receive as well. One, what if I have a sentimental item that I want to keep after divorce? This is a common question we get, both from parties that are looking to maintain family heirlooms, firearms, jewelry, furniture, other things of great significant value to them. It's important to keep in mind that you have the opportunity to reach a settlement agreement with the other side, where it's agreed on what items you will keep and what items they will keep in the process. Alternatively, there's the possibility of going to mediation or to trial to fight these isolated issues of specific items of property that you want to keep. But keep in mind that if you communicate these things early to your Oklahoma divorce attorney, it will help them to build a structure and a strategy to help you try and maintain those items. Great question. Second question we received, how do I handle that in the division of property? It's important to keep in mind that by identifying the key elements of your property, real property such as your home, vacation home, vehicles, financial assets, other items. This helps you and your attorney to build a financial portfolio that lays out all of the assets that are part of the divorce and assets that are separate property and can be separated from the divorce process as a whole. When you work with your attorney to help identify all of these issues, you can build a strategy to effectively divide property in a way that is of interest to you, but also protects the fairness of the process. Third question we received for today, what are some things I can do to prepare myself financially for life after divorce? It's important to keep in mind when you work with an experienced family law attorney, they should be able to help you in building a financial plan and budget for the way forward, whether it's housing expenses, the day-to-day needs of life, child support that you are paying or receiving, spousal support or alimony that you are paying or receiving, and really complete financial picture for your peace of mind to ensure everything that can be done is being done to prepare you for life after divorce financially. Four, what arrangements can be made if one parent wants to relocate after divorce? It's important to keep in mind that this is one of the important issues that can be resolved by agreement of the parties. If you have a plan to relocate without being the primary parent of the child, it is very easy to reach an agreement between the parties for what visitation and custody will look like. Alternatively, if you're seeking to relocate with the child, it can make it more contentious and difficult to reach a resolution because the presumption is if one party is going to want to have continued contact or visitation with their child, it's much more difficult if the parties live in different cities or different states. Now, relocation can be resolved by agreement if the court will accept a proposal, but this is one of the more contentious issues that makes it important to speak with an experienced attorney to answer or address your questions about that issue. Five, one of the next common questions that we get asked is, what about our pets? Who gets custody of Fido after the divorce is settled? Again, pets are treated as personal property, more similarly associated with the television than with the child, despite how many people feel about their pets, myself included. I love my dog, Bear, dearly. But he is treated as an asset, not as a child in the divorce process. So when the parties are reaching resolution of division of assets, it's important to keep in mind that if you're going to reach a settlement as to who keeps Fido or who gets the family cat, this can help you to avoid the costly expense of litigating these types of issues. However, if no resolution can be reached on who's going to get your family pet, you absolutely have the right to fight that issue out through discovery process, through mediation, or even going to trial. You would not be the first person that I have seen to go to trial over the family dog. One of the other common questions that we get asked and someone threw out for today's purposes is, my spouse and I are on good terms. Can't we just write everything down ourselves and avoid lawyers? Yes, you can, in theory, get an example divorce decree and draft everything out. However, you would be operating without the experience, wisdom, and advice of someone that's been through this not 10, but hundreds or potentially even thousands of times with clients. When we write out a divorce decree for our clients, we're not only looking at things as they stand today, but also how can we insulate the parties, specifically our client, from having problems a year, 5 years, or 10 years and beyond down the road. There are issues that we can resolve now that can help you to avoid going back to court down the road, whether it be the visitation or custody plan for your child as they are aging and moving to different places or different maturity levels in their life. Their needs will change from being an infant to a toddler to a young child to teen years and beyond. Also, the division of assets. Some things are best to be left alone for the time being, but divided at a later point, such as a qualified domestic relation order or a quadro, which can be something that provides the definition of how an asset or retirement account will be divided, but does not divide it until much, much later. There's also tax implications to keep in mind. If you have assets in the divorce that you need to make sure are protected, there are ways that divorce settlement can be structured to mitigate the tax damages from transferring assets in the divorce process. Great question about whether or not you need a family law attorney. I would encourage you that if you're going to need to have a medical procedure, you go to a qualified, experienced, and licensed physician, and don't go to YouTube or WebMD and try and operate it yourself. A little bit of a jest, but I think the same thing applies when you're seeking to resolve your financial assets, your future, and also potentially what's going to happen with your children now and beyond. Another question we received for today is, my spouse makes a lot more than me. What can I do to try and make sure that I'm taken care of? Well, when the spouses make different sums, this is really an issue of spousal support or alimony. And so the first consideration in Oklahoma law on the alimony issue is there a need for these spousal support or alimony? And does the other party have the ability to pay it? And so that kind of leads into our next question of, will I get spouse support? Again, the court does not have to place you in the exact same financial situation you are now after the divorce process. But there's a period of time that is presumed that both parties will live as similar lifestyles beyond divorce as they did while they are married. So it may not seem fair to those that don't have this dynamic, but for the people that have been living a lifestyle that costs over $10,000, $15,000 a month, uh, vacations, expensive trips, expenditures, country club, expensive vehicle lease payments, clothing allowance, going out to eat regularly, the things that add up to the expense that a family has in a month can easily blow into $10, $15, $20,000 a month. And we've seen that for clients. And so if you are going through a divorce process in that situation, you will not immediately go to the poorhouse, so to speak, in your divorce process. Either the parties can reach some type of an agreement, or you absolutely have the right to go to court and fight for temporary spouse support and also spouse support or alimony after the process to help ensure that you maintain somewhat your current lifestyle. Now, that's caveat with the idea that the court presumptively is not going to just provide that for you indefinitely. And so if you are the spouse that's been dependent or the homemaker, you have an uphill fight to try and protect your interest to maintain somewhat of the same lifestyle you have now beyond the divorce process. And that also can be accomplished through the division of assets, not just direct support alimony. The other side of that coin is, am I going to have to pay the substantial amount of support alimony? And again, that's an important reason why you should work with an experienced family law attorney that's represented high net worth individuals in the past. Because the issues that you will face on trying to mitigate your exposure to support alimony for a long period of time are different than a family that's making $60,000, $80,000, $100,000 collectively in a year, because just the amount of resources available for support alimony are substantially less. So if you are the spouse of a high earner, or if you're the high earner yourself in the divorce process, it is crucial you work with an experienced attorney to help develop a strategy on how you can mitigate the situation and try and structure it in a way that's equitable to both parties, but also serves your current and your future financial needs. Sorry for how in depth that was, but that's a really confusing issue sometimes. I want to make sure we've answered that person's question on what they're trying to get at. If that didn't answer your question, please feel free to reach out to us or leave comments below. Next question that was submitted us today is what is considered marital property and separate property in Oklahoma? Oklahoma is a communal property state, which means things that are generally acquired during the marriage are considered marital property or part of the marital estate. However, things that are acquired during the course of the marriage that can be qualified as an inheritance or a gift to one party, or things that are acquired before the divorce was started, pardon me, before the marriage began, is typically considered personal property. So if I have an object that I brought into the marriage, oftentimes there's a way to keep that as my separate property that would not be divided as part of the marital estate. Conversely, if something is attained during the course of the marriage, it is typically considered marital property and would be part of that marital estate that has to be factored in to dividing out assets, whether they're accounts, investments, real property, or personal property. But one other important takeaway is there's the concept of tracing, where you're tracing where things came from and their origin. And this is something that an experienced family law attorney, especially one that can work with a financial advisor or forensic accountant, can help you ensure that you've documented the tracing or the origination of these different assets to either protect your interest or ensure that the other side is not unfairly benefiting from separate versus marital property in your divorce. Great question. Uh, Next question we received today: how will a divorce impact my health insurance coverage? Insurance coverage is a debt that is paid by the marriage or one of the parties during the course of. Short of an agreement of the parties, spousal support does not always include the payment of health insurance. So if you've been the dependent spouse, you need to ensure that steps are taken to protect your provision of health insurance beyond, or calculate that in the division of the marital estate so that you can protect yourself beyond the divorce. Now, real quick caveat to that in the military, and I personally have TRICARE as a service member, and many of our servicemen and women and their families use TRICARE for their health insurance through the U.S. military. There are only certain circumstances that allow a spouse to be able to maintain that beyond the divorce. And just generally speaking, for the purposes of this information today, if your service member spouse or if you as the service member have not been in 15 plus years and married to the person that's the other party to your divorce for 15 years, this probably doesn't apply, and that spouse is not going to be entitled to military health insurance through TRICARE after the divorce. But the 2015 rule, 20 years of service, 15 years overlap marriage, or the 2010 rule, 20 years of service, 10 years of marriage, or the 2020 rule, 20 years of marriage, 20 years of overlapping service. These calculations determine what, if any, TRICARE military health insurance your spouse will be entitled to. Sorry for that tangent, but for some of our service members and their spouses, that's a key point. Next question we received: what happens to the house and other real estate in a divorce? Again, this is the issue of whether there's an ability to identify the marital home or real estate as separate property or something that was gifted or an inheritance or obtained separate from the marriage. There's also the issue that comes up often with real property of commingling. So if I in a marriage bring in a home that we live in, if we expend marital funds throughout the course of the marriage to maintain the home, insurance, upkeep, cleaning services, paint the house, refurbish, do renovations, all these things can point towards that separate piece of property that was brought into the marriage being commingled, the waters being muddied, and it becoming at least partially attributable as a marital asset that both parties get attributed some value in that property. But most cases, real property in the marriage is the marital home. And in most circumstances, short of a prenup that says something otherwise, or the ability to segregate or trace that asset is separate from the marriage, the marital home is going to be marital property, which means in almost all marriages, the home that the parties live in is going to be marital property. Same analysis applies on separate vacation homes or other real estate. But if you cannot show that came from a separate endeavor than the marriage itself, if you can't trace to a separate origin, then most real property is going to be identified as marital property and subject to division. Now, if you own rental homes, if you own a large amount of real estate, if you have a property company, if you own your own business, All of these things are factors that go into whether or not you need a qualified, experienced marital attorney. And these issues are crucial to work with an experienced lawyer and their team so that you can ensure you have a clear picture with your attorney of what the financial landscape looks like, all of the assets, all of the real estate, and begin the process of fighting for either showing that these items are separate property and should be separate from the divorce proceeding, or your interest that they are marital property and you should be attributed part of their value in dividing the assets. I've personally represented many people on both sides of these large property divorce cases, and it's crucial to have a clear picture of the issues and a strategy in place for how you're going to advocate for your interest in the division of property, whether by settlement, mediation, or trial itself. The last question that we got today that I want to speak to you about kind of goes in line with that last bit we were discussing. But if someone has a family business, how will this be affected during and after divorce? So, business interest and division of a business estate or the property that's involved in the business itself. Again, it comes back to tracing. Is it separate property? Is it marital property? What impact has the spouse had on the increased value of that business? And also, is there a prenuptial agreement, or in some states, a postnuptial agreement in place that dictates how that business will be treated in a divorce process? If you own a business or multiple businesses, or conversely, if you're the spouse of someone who runs multiple businesses, or if your family owns a business, it is crucial you work with an experienced attorney because you not only need to determine whether you should be attributed part of the value, but also evaluating the total value of that business and its future value. How will it increase in value over time, and how much of that should be attributed to you? I can tell you from lots of experience representing people in this dynamic, to the extent possible, it's best to separate the businesses to where this party maintains these businesses and this party maintains these businesses. Or alternatively, one party keeps the family business and the other side is bought out or given some cash or some other asset of value to balance out losing their interest in that business. There are few things that are more uncomfortable than maintaining a family business with your ex. I hope that these questions we've discussed today and the topics about the 3 do's and don'ts in divorce have helped you in evaluating the process, or at least sparked your curiosity and helped you identify things that you should be thinking about in this process. If you have questions about your divorce, I encourage you to click the subscribe button, review some more of our content on our website. We also have a book that we've published, Informed Divorce. You can obtain a digital copy off our website. You can get a hardback copy by calling our office, and it's also available on Amazon. We put all these resources out to help you through the process to get clarity on your situation. And if you have any specific questions, please reach out to us for a free, confidential, no questions asked case strategy session.